Is the Tuesday, March 20th hearing of the Assembly Judiciary Committee. I'm Mike Fewer. I chair the committee. We will begin in just 20 seconds. We are just a little short of a quorum, but we will commence as a subcommittee. Item number 3 by our colleague Ms. Olson has been pulled from the agenda. And I think our first author this morning is Mr. Gatto. Mr. Gatto is here on item 2, AB 1624. Good morning. Welcome.
Thank you. So AB 1624 is a rather simple measure. It corrects a sort of unjust court decision that stands for the premise that whoever races to the bank first in a multi-party account and withdraws the funds becomes the owner of those funds. This is a rather disturbing inequity, and it could hurt our senior citizen population. This bill will protect our senior citizen population and anybody else who has a multi-party account. So I respectfully ask for your vote.
Thank you very much. Your first witness in support, please.
Larry Doyle, on behalf of the Conference of California Bar Associations. The conference has been working on this proposal for a couple of years and is very, very supportive of this bill. Mr. Gatto described it very well, and the analysis does a fine job of analyzing it. I'm here to answer any questions if you have
Thank you. Your next witness in support, please.
Casey Young with AARP in support. Unfortunately, it's often trusted relatives that are charged with paying bills and so forth that take advantage, and this court case opened the door to more of that, and so we're very appreciative of the author's effort to close this. Thank you.
Thank you very much. Other witnesses in support of Mr. Gatto's bill? Are the witnesses here in opposition to the bill? Seeing none, colleague, questions for our colleague, Mr. Gatto? Okay, there are no questions, Mr. Gatto. It's a pretty straightforward piece of legislation and explained well. We don't have a quorum, and so we can't move the bill at the moment, but we have a short agenda, and it'll be taken up a little bit later. Would you like to close?
Just ask for your aye vote, and hope your colleagues are watching on TV.
Yeah, you fortunately wore your good suit today, Mr. Gatto. That's a good choice. Thank you. All right. Our next item is Mr. Lara's bill, which is item number 5, SB 1670. Oh, I see. All right. So is Mr. Allen here to present on AJR 22? Well, Mr. Wachowski has just arrived. So why don't the two of you feel free to present AJR 22.
The Assistant Majority Floor Leader, Mr. Allen. As you may have read from the excellent staff report, AJR 22 is part of the national movement to overturn the United States Supreme Court ruling in the Citizens United case. I was listening to NPR, I think last week, and they had Senator Feingold on, and he was making the point that there are very few cases that the public knows about. He said, you know, you think about it, you got Roe versus Wade, you got Brown versus the Board of Education, and then, you know, the public at large doesn't have a lot of cases. Everybody knows about Citizens United, and everybody knows it's bad. It's bad what the Supreme Court did, this very controversial decision that's created a firestorm. Voters whose trust in government is already low are now being subjected to a barrage of negative campaign ads funded by wealthy special interests. I think it is telling that both President Obama and Senator McCain, the last two presidential nominees, are both strongly opposed to this ruling. President Obama has said, I don't think American elections should be bankrolled by America's most powerful special interests, or worse, foreign entities. And Senator McCain called the decision an outrage and said, "I condemn the United States Supreme Court for their naivete." The decision has helped lead the way for super PACs, which are now dominating our national political landscape, and evidently Illinois is going to be the next recipient today and tomorrow as they vote. Since 1907, Congress has passed laws limiting the role of corporations and later unions in the electoral process. Before and after the Buckley versus Valeo decision, the court maintained corporate campaign expenditure restrictions. On several occasions after Buckley, court opinions said differing restrictions on individuals and unincorporated associations on the one hand and corporations on the other reflect a judgment by Congress that these entities have differing purposes and therefore may require different forms of regulations to protect the integrity of the electoral process. Justice Stevens summed up the Citizens United ruling when he said in the dissent, "The court's opinion is thus a rejection of the common sense of the American people, who have recognized a need to prevent corporations from undermining self-government since the founding, and who have fought against the distinctive corruption potential of corporate engineering since the days of Theodore Roosevelt. It is a strange time to repudiate that common sense." Now I'd like to turn it over to the joint author, Assemblymember Allen. I hope that the message, AJR 22 sends a message to those in Congress that we agree with Justice Stevens.
Mr. Allen.
Chair, fellow members of the committee. The corrosive effects of big money on democracy are the legal equivalent of yelling fire in a crowded theater. A reason to regulate free speech rights under certain circumstances. We must find a better balance between its protection of free speech for corporations and the rights of democracy to protect itself from large campaign donors. Super PACs, which we've seen the rise of since the Citizens United case, owe no allegiance to parties nor to candidates. They are essentially creating an incredibly corrosive effect on democracy, eroding the credibility of the citizens when they participate in the political process. Since 2012, and this figure is incredible, just simply from 2012 already, $130 million has been raised by the super PACs, and the majority come from very wealthy individuals. So you'll be hearing testimony today, but we feel that many are calling upon legislators as their civic duty to do something about this issue and to find ways to limit the ruling of Citizens United and perhaps overturn it. So that's why we're here today, and thank you.
Thank you very much to both of you. Let's hear from your first witness in support, please.
Yes, Mr. Chair, we have Derek Cressman from Common Cause and Mr. Pedro Morales from CalPERS.
Yes. Actually, feel free to testify from your chair.
Thank you. I'm Derek Cressman with California Common Cause and would like to commend the authors and the committee for taking the time to consider something that, after all, is a pretty big deal. It's not every day that we talk about the United States Constitution. But at Common Cause, we believe that it is time for all elected officials who have taken an oath to defend the Constitution to use the checks and balances that are part of that document and part of our government to correct an overreach by 5 justices of the United States Supreme Court. That's what we believe the Citizens United ruling entailed. And it's not just the law that was overturned in that particular case, which the staff report outlines very well, but the precedent that was set by that case and cemented in that case that really involves 3 different aspects. The first is the notion that corporations have constitutional rights above and beyond and separate from the individual rights of their shareholders. The second is that unlimited spending on political campaigns is the same thing as free speech when the First Amendment talks about free speech. And the third principle that really got cemented in the Citizens United ruling is that an independent expenditure of an unlimited amount of money cannot possibly be corrupting. And it was that notion that really blew away the old campaign finance laws at the federal level that were put in place after Watergate, when you had the President of the United States walking around with suitcases that had $1 million in cash in them. these 5 justices would have us believe that as long as that suitcase is not in the Oval Office, but in a different office handed to the former chief of staff or former campaign manager of the president, that suddenly we have no problem. Now, the vast majority of Americans do not believe that to be the case. 4 justices of the current Supreme Court do not believe that to be the case. And what you have the opportunity today is for the California legislature to decide if you believe that's the case, or if, in fact, the Constitution never said that corporations have the same rights that real people do, never said that spending an unlimited amount of money is the same thing as free speech, and that there is no corruption risk or distortion when you have unlimited amounts of money going into independent expenditures. So would encourage the Assembly to do that, California legislature to do that, and thank you for your time.
Thank you. Next witness in support.
Thank you, Mr. Chair and members. Pedro Morillas, I'm the Legislative Director for the California Public Interest Research Group. Also in support, money in politics has been a problem for a long time, but the Citizens United decision took a bad situation and made it exponentially worse. And we're seeing just how much bigger this problem and how much more of a role money has to play in politics in the current primary election that's going on. And it's not even, the general election hasn't even come around, and already we're measuring the amounts of monies in hundreds of millions of dollars. So the problem is massive. And given the makeup of this Congress, the idea of a constitutional amendment is a little bit unrealistic to start at the federal level. The strategy and the idea is to get the states all on the same page and send Congress a message saying that the Supreme Court got it wrong. Corporations shouldn't have the ability to spend unlimited amounts of money for political purposes. And this resolution, and California in particular, can play a huge role in this fight to move the ball forward and really send Congress a message that we need to do something about this problem. And so I would urge this committee to move the resolution forward, and I thank you for your time.
Thank you for your testimony. Before we continue on this legislation, we have now a quorum, so why don't we establish that, please?
Fuhrer?
Here.
Wagner? Here. Atkins? Here. Dickinson? Here. Huber? Here. Jones? Here. Monning? Wachowski?
Here. Is there a motion on the consent calendar? Second? Okay, call the roll, please.
Fuhrer?
Aye.
Fuhrer, aye. Wagner?
Aye.
Wagner, aye. Atkins?
Aye.
Atkins, aye. Dickinson? Aye. Dickinson, aye. Huber?
Here. Or aye.
Huber, aye. Jones?
Aye.
Jones, aye. Monning? Wachowski?
Aye.
Wachowski, aye.
Okay, the consent calendar is approved. Are there other witnesses in support of the measure by our colleagues, Mr. Wachowski and Mr. Allen? Please state your support for the legislation.
Yes, I'm Elizabeth Scholes, Director of Public Policy for the California Church Impact. We represent 1.5 million members in the mainline and progressive Protestant denominations who are the likely voters, and we strongly support this resolution.
Thank you.
Mitch Seaman, California Labor Federation, also in support.
Thank you. Others in support?
I'm Susan Harmon. I'm from the East Bay and Oakland Move to Amend. Thank you. And we're very grateful to Mr. Wachowski and Mr. Allen for responding to Citizens United, which, as everyone has said so far, is a disaster for democracy. But it deals with, I have here a timeline of corporate abuse, and I think you can see that Citizens United is down here in 2010, occupying maybe the last foot of this timeline of corporate abuse. What it doesn't take into account is the other 150 years of corporate abuse. A very concrete and dramatic way of illustrating that we need a much broader resolution.
It's also a concrete and dramatic way to reveal that all of us here must need glasses because we can't necessarily read all the print on there. Okay, thank you.
We're happy to leave it with you for a while for you to study. And also on our website, colleague for Peace and Freedom from Poplad, who's been working on this issue for decades. But if this resolution doesn't say money isn't speech and corporations are not people, we'll just have to come back and do it all over again. So we're urging you to amend this resolution before it goes to the floor and include the 150 other years before Citizens United.
Thank you very much for your testimony. Others in support?
Good morning. My name is Pete Lederman. I'm an attorney living in Berkeley and have been involved with the Move to Amend folks. I want to commend the resolution. I hope in particular it will spur the state of California to support the state of Montana, which, as you may know, has had a case where it specifically said, we believe that the money from direct corporation expenditures on elections does corrupt the politics of the state. They now have a case their case has been stayed by a couple of justices of the U.S. Supreme Court, so I imagine it may very well come before the U.S. court. They have found that indeed there is a compelling government interest in limiting corporate expenditures to avoid corruption of the political process. California should join them, and I think that this resolution will permit the state to do so. I hope so.
Thank you. Others in support?
My name is Joseph Rosas from Sunnyvale, a network security advisor, a member of Occupy San Jose, and a candidate for State Assembly in District 24. As a network security advisor, we do a lot of DDoS mitigation, distributed denial of service attack. And this is, Citizens United has allowed a distributed denial of service in terms of money in our political system. The purpose of a denial of service attack is to flood any network resource with as much traffic and more than it can handle in order to block any further access. Citizens United allows the flooding of money to block out anybody else's speech. If money is speech, then do you have no speech if you have no money? For this reason, I come on behalf of Occupy San Jose saying that we have officially endorsed this bill as a General Assembly and urge you to please pass it. Californians need to be proud of their government again, and this is a small step in order for you guys to help us be proud of California again.
Thank you. Next witness in support?
I'm married to ZHU. I'm a retired physician from Davis, California. I'm part of a very small fledgling grassroots group called Take Back Our Democracy, and we, like much of the country, majority of the country by polls, are alarmed at corporations' money buying our vote. I find it very comprehensive, and I do think it's far beyond us to speak to the wording of any actual amendment. So let's go with it, and the fine points can be ironed out. This is a beginning. Thank you.
Thank you.
Hi there. My name is James Hahn, and I'm from Redwood City, and I'm a media spokesperson with Occupy Redwood City, and I come here to say that our Occupy movement has also endorsed AJR 22, and we urge you to move this resolution forward to the full assembly for a vote. I want to speak as my perspective as an occupier. We've had, some of you probably know that the reason why Occupy has gained steam in the recent months has been because people have been growing disenchanted with their government, thinking that government does not speak for them, in which the Citizens United case kind of illustrates quite profoundly. We've had debates in our Occupy movement, and I've seen it in other Occupy movements where people are asking us, why are we as an Occupy movement endorsing a legislative resolution? Why are we doing this? We're here because we know the system doesn't work, and we want to work outside the system and create change. Some of us are here because we kind of do believe that the system is broken, but we believe that there's stuff that can be done within the system, and that things can be done to restore faith in our legislative process. So again, we urge you to move this bill forward, and we will be keeping an eye on what happens with this bill in the future and who supports it and who doesn't. Thank you very much.
Thank you. Others in support?
I'm Mildred Livingston. I'm from Auburn, California, and I'm here on behalf of the Sierra Foothills Women's International League for Peace and Freedom, and we support this resolution and counting on all of you to do the right thing. Thank you.
Please.
My name is Patricia Grenfell. I'm a retired financial analyst from Hewlett-Packard. I'm here representing organizations to which I'm a member, Public Citizen and Common Cause, and also Placer 99%. And I urge California to join Hawaii and New Mexico to become the third. We have an opportunity to become the third state to encourage this effort. We need to amend the Constitution. Thank you.
Yes, please.
My name is George Farmer. I'm from Davis, California. I'm a member in good standing of the 99%, and I'm in wholehearted support of what you're doing and wish you well. Thank you.
Thank you very much.
My name is Marlene Sarnat. I'm from Rio Vista, California. I'm also part of the 99%, and I'm here to speak in favor of this resolution. Thank you.
Very good. Are there any witnesses here in opposition? Any witnesses here from the 1%? All right. So, colleagues, questions or comments for Mr. Wachowski or Mr. Allen? Mr. Dickinson.
Mr. Chairman, thank you. I just have a brief comment because I thought the analysis was the committee analysis was excellent. But I actually think that it's no surprise that we find ourselves in this position because we started down this path with Buckley versus Vallejo. And so, sad to say, I think we are realizing the legacy of that decision. None of us, I think, take lightly the notion of amending the United States Constitution. It is something that is considered only under rare circumstances as a result and part of our history as a nation, and I think we're better for it. In fact, comparing the United States Constitution to the California Constitution, one might conclude that less is more. But I can't discern a way to limit the extent and impact of the Citizens United decision, except in two ways. That is to look to the Supreme Court to overturn it, or to amend the Constitution. And since I believe the former is highly unlikely anytime in the foreseeable future, if ever it leaves the recourse of supporting amending the Constitution. That's why I'm a co-author, and that's why I support the resolution. Thank you.
Thank you. Other questions or comments, colleagues? Mr. Wagner.
Well, I wasn't going to weigh in essentially because of the futility of doing so, but I will follow up and have to agree on at least one thing I just heard from my colleague, Mr. Dickinson. It is clear to me Buckley versus Vallejo is what set us on the wrong path. And it and its progeny are efforts to go down that path, alleviate some of the problems that Buckley created, and we've just continued to make a further hash of the situation, quite frankly, including probably with the Citizens United case, which is compelled by much of that confused prior law. I think we do have a guide in the First Amendment as a way to get back on track. The First Amendment, Congress shall make no law abridging the freedom of speech. It also applies to the freedom of religion and the freedom of association. It does not say Congress shall permit the government to abridge speech of people and of associations that the majority doesn't like. The Supreme Court has noted that laws in the Citizens United case, such as the restrictions that are being requested here, function as the equivalent of prior restraint by giving the government power, essentially power it is not entitled to have, and power that the First Amendment, quote, was drawn to prohibit. That said, it seems to me we are well down a path that probably everyone in this room, for various different reasons, would suggest we not go. This AJR poking at one of those decisions is, in my view, too narrow a focus. What ought happen is all of us urge Congress to go back and revisit the fundamental underlying principles of Buckley, the assumptions that are there and are in all of the campaign finance laws that have arisen since then, to perhaps take another look at McConnell and this McCain-Feingold, and in the course of that, take a look at Citizens United. But as this bill is focused just on one of those three cases and one of the whole progeny of cases following Buckley, it is too narrowly focused. It is too far away from what should be our guiding principle, the First Amendment, and for that reason, I'm going to have to oppose it.
Mr. Monning.
Thank you, Mr. Chair. I want to thank the authors for bringing this forward, and I'm also encouraged to hear from my colleague, Mr. Wagner, that he would favor an even more expansive review of the bad road our campaign finance laws have proceeded. With respect to this resolution, I think it's fully appropriate to galvanize attention on what I think is an usurpation of the intent of the framers of our Constitution, a First Amendment that seeks to protect free speech, but also a freedom of playing on a level playing field. And that's what we've lost with Citizens United. We've heard testimony from people identifying as part of the 99%. In my view, Citizens United affords greater voice, louder voice to members of the 1% who can write the bigger check. And for our First Amendment to be reduced to the notion that free speech is a function of your ability to pay guarantees that some will have a louder voice than others. So I just want to offer my support. You'll have my yes vote. And if I'm not already a co-author, I'd like to join as a co-author. Thank you.
Thank you, Mr. Monning. Colleagues, other questions or comments for our joint authors? Seeing none, I just want to add a couple thoughts. The fundamental problem, on my view, with Citizens United is found in other case law, which speaks of the distortion of the political process by huge amounts of campaign expenditures by institutions that bear no relationship to public support for specific ideas in the electoral process. That's where the action is, on my view. And Citizens United throws all that out the window and basically ignores the distortion that we're seeing. And for what it's worth, it didn't take very long, as we all know, for the impact of Citizens United to be felt. It's been felt in every Republican primary we've seen so far. And commentators across the board acknowledge that it has been felt right now. So we can continue to abide the enormous impact of the so-called super PACs, which is, to me, kind of allows us to be anesthetized to the impact, because those words don't have the meaning that they really should. What the super PAC phenomenon means is a small number of people who control enormous quantities of concentrated wealth are able to flood the airwaves and, in the words of previous judicial decision-making, utterly distort the political process. That serves no one. We should be focused on the best ideas winning out, not who can flood the airwaves with the most money, particularly in the least accountable way possible. Because that's another aspect of Citizens United that we ought not overlook, and that is, at least when anybody running for office puts an ad up, there is some nominal level of accountability associated with what is said, how the money is raised. There is a display of who supports and so forth. In the wake of Citizens United, this concentrated wealth can hide behind a broad umbrella. No accountability whatsoever. This is not good for democracy. So even as I think the critique offered by Mr. Wagner has some merit, that there is the potential for more breadth to this conversation. I think you'd find common ground for that idea here. That is not the resolution before us. And on my view, as with many pieces of legislation, simply because a proposal doesn't solve every problem doesn't mean that which solves some part of the problem shouldn't go forward. And I think it should. There is a critique that's offered by some of the supporters of the bill that the resolution isn't specific enough. But I think that while there may be some merit to that idea, if we were the body to whom the resolution was addressed, this resolution is addressed to Congress, where I understand there are multiple ideas pending. The more specific this resolution gets, the less weight it will have if it is not directly replicated in a specific piece of legislation in Congress. There needs to be some flexibility here because we don't ultimately control what is going to be happening in Congress. For those reasons, granting that there could be, in a better world, a very specific directive that cites a whole number of particulars, that's not where we are. Congress has multiple ideas before it. This proposal says we should support those ideas in multiple iterations at the moment. I'm going to support the measure. So, Mr. Wachowski, Mr. Allen, do you wish to close?
Yes, and I'll just comment that we intentionally do not support specific language because, like this body, Congress is going to do what Congress is going to do, and there's many different proposals floating around. There's going to be ample time for Congress to work out the language that they want as far as limitation. I believe that the robust testimony that we had today from Common Cause and CalPERG and Move to Amend and the California church groups and the Labor Fed are evidence that this is something that folks are talking about over the kitchen table. People all over the United States are concerned about it. I understand that we've been gathering petitions, and there's 10,000 people in the state of California who signed a petition to support this broad resolution. I respectfully urge your aye vote. My name is Bob Wachowski, and I approve this statement. No. Mr. Allen here also has a short close for your indulgence, if you can go ahead.
All right. Mr. Allen, did you approve Mr. Wachowski's statement?
Not really, but we can go with it.
All right.
You know, I'd just like to say to the members of the committee is that I truly see this as a bipartisan issue, actually broader than that. Anyone who's engaged, whatever party in the political process, should want to see the return of some form of regulation. So because it's an AGR, we wanted to represent the sentiment of the entire legislature. So we invite co-authors, we invite suggestions as we go forward, but it really should embody the sentiment of the entire legislature. And it's something that, as mentioned by previous speakers and witnesses, what we're trying to do as elected representatives is listen to the people and then acknowledge what we're hearing from what we believe is the vast majority, that we do want to restore democracy in the sense of not being flooded with incredible amounts of money that subvert speech by overwhelming it with resources that create an unlevel playing field. So we urge an aye vote, and we thank you for listening to us today.
Thank you very much. Is there a motion on the bill? Mr. Dickinson moves. Is there a second? Ms. Atkins seconds. Call the roll.
Fear?
Aye.
Fear, aye. Wagner? Wagner, no. Atkins? Atkins, aye. Dickinson? Dickinson, aye. Huber?
Aye.
Huber, aye. Jones? No. Jones, no. Monning? Aye. Monning, aye. Wachowski? Wachowski, aye.
That measure has 6 votes and is out. Congratulations to the authors. We'll now hear from Mr. Lara, item number 5, AB 1670. Mr. Wagner, would you assume the chairmanship for one moment, please?
Thank you,
Mr. Lara, you're here on AB 1670. You may begin.
Thank you. Is this on? Thank you. Can you hear me? Okay, perfect. Thank you, Mr. Chair and members. AB 1670 will simply provide the ability for a non-resident heir to nominate a qualified person to act as the administrator of his or her inherited estate. This bill does not allow them to be the administrator. Under current law, when an individual dies with a valid will, a court is authorized to appoint a person known as the administrator to act as their individual personal representative to administer the estate. If the appointed person designated in the bill is a non-resident of the United States, he or she is allowed to act as the administrator. However, if the person dies without a valid will and their heir is a non-resident under current law, the heir does not have the authority to nominate a person as the administrator of his or her estate. As a result, the non-resident heirs have no say in who acts as the administrator of his or her inherited estate, and to handle the estate frequently has no ties to the descendants. With me to testify in support today, is Mark Weideman, legislative advocate for the trust and estate section of the California State Bar, and Jim Lamping, who is a certified specialist in estate planning and probate and trust law, to answer any questions that you have.
Thank you. Mr. Weideman.
Thank you, Chairman Wagner. Mark Weideman on behalf of the Trust and Estate section of the State Bar of California. We bring this bill here to you. It went through a process where it was vetted thoroughly by trust and estates attorneys. These are attorneys that represent heirs, they represent decedents, they represent creditors. So they represent all aspects of probate proceedings. These attorneys have gotten together and decided that there is an injustice in the system, that non-residents are being treated differently in the process. Their estates are automatically being reverted to public administrators for handling during the probate process. And they felt that that was unfair. They had 28 votes in favor of this bill or proposal, no votes against it, coming from all aspects of the probate process. They did not see any door opening to additional fraud that might otherwise exist if you're dealing completely with residents. There is no opportunity for additional fraud here. What this is about is it's about non-residents being treated differently under the law, and public administrators being automatically appointed in those situations. And that's simply not fair when you have kin, you have heirs that should be able to make those decisions on who's going to be appointed administrator in the case. Jim Lamping is a certified expert in this area of law, and he has a few comments he'd like to make, and he's available to answer questions as well.
Thank you, Mr. Lamping. Go ahead.
Just to pick up on those comments, this will not increase fraud, and it will not produce any less reliability in the probate administration process. That while non-residents will be entitled to nominate who will be the person who will be administering the estate and administering the assets the family will ultimately be entitled to receive, the administrator, the person who's administering it, must be a United States resident, will be subject to jurisdiction in California, and if they engage in fraud, they will, just as any other administrator, they will be subject to jurisdiction in California. They will be personally liable, for example, if they distribute funds without paying the creditors. And so fraud, there isn't really, we aren't opening the door for fraud by having this bill. In addition, probates, generally the administrator is required to have a bond, so that if the administrator does, if you do have a rogue administrator who takes off and distributes funds when they shouldn't, the bonding company will reimburse the estate and then go after the wrongdoer. So the possibility of fraud really isn't there. As far as someone, a foreign or a non-resident person coming in and claiming to be an heir when they're really not, that also really isn't an issue. The administrator who's appointed, once they're appointed, will have the obligation to go out and to determine who the heirs are, just as any other administrator would. And if they don't, again, they're personally liable for misappropriated assets. What's really happening here, the only thing that I can't dispute, is that the Public Administrator's Office has said that they will no longer be able to interpose themselves over the objections of the non-resident families, and that I can't dispute. But I would ask, why is it that these families in particular should be singled out and treated differently than any other family? If we're going to take that approach, we might as well say that every 20th probate in California should be administered by the Public Administrator's Office because they need the money. That really isn't an argument. Depriving a family of the opportunity to appoint or to choose who's most appropriate to administer an estate is not, just because of their funding issues, is not really an appropriate reason. And so for that reason, the Trust and Estate section of the State Bar sponsored this bill and feels that it's appropriate.
Thank you. Other witnesses in support? Witnesses in opposition? Good morning.
Good morning, Mr. Chair and members. Trent Smith on behalf of the California State Association of Public Conservators, Public Guardians, and Public Administrators. This bill, or a proposal similar to it, came before the legislature by the same sponsors back in 1999, and our client at that time also opposed it. We believe wisely the legislature at that time rejected the proposal for many of the policy and fiscal reasons that we remain opposed today. First of all, in policy, it's been stated that it's just not fair if someone lives outside the United States that they should be treated differently than someone who lives inside the United States. We submit there is a fundamental difference, and that is if you live outside the United States and you appoint someone to represent your particular interest and you go through the probate process and you're allowed to take assets that are granted to you and leave the United States, that there is no second bite at the apple, which means a creditor who feels that they did not have the appropriate opportunity to make their case in the probate process, we're not aware of it, they have no ability to go after those funds. Same for a particular heir. We are assuming here that the heir who makes the appointment, the heir who lives outside the United States, is the proper heir to that estate. And that's not always the case. I know it has been presented that the courts will oversee this process. There's a bonding process, and that will ensure that the probate is handled properly. However, I think most of you listened to the Chief Justice yesterday and know the status of our particular court system today. The probate courts are overwhelmed right now, and they move things through the process, and they have to take they have no independent ability to go out and research on their own. They have to take what is submitted to them by any representative as what is, in fact, the case. And I'm not suggesting, nor are our clients suggesting, that there is going to be open fraud. However, you just need to consider that when you make an appointment, and in many of these cases, there's a whole cottage industry of heir hunters out there who actually approach the individual and say, hey, did you know that you're eligible to inherit a large sum of money from this particular estate? And I will represent you, or have someone represent you, for a percentage of the estate that goes back to that particular individual. That creates an inherent conflict where a person is going to be representing that particular heir's interests over the interests of the estate and other potential heirs and creditors. And again, I'm not suggesting that that means they are going to act fraudulently, but when when your income is predicated on how much you are bringing your particular client, that creates a different set of standards than what a public administrator who only cares about the particular estate, creditors, and heirs, not who one particular heir. On the fiscal reasons, again, you've heard that a public administrator must administer all of these estates. That means whether there's any assets or millions of dollars of assets. And I'll just tell you right now, vast majority of them do not have a lot of assets or have a lot of creditors. That means they must, by law, administer the estate at great loss to that particular county which funds the public administrator's services. On the rare occasion that they do have an estate that has assets, like the ones we're talking about here, they are able to charge a reasonable hourly rate, not a percentage of the overall estate, but an hourly rate to collect money for their services. And in many cases, that revenue helps offset the cases that are money losers for the other counties. Now, I've heard That's not a good policy. We shouldn't have a few individuals use their revenue to pay for all the other estates that don't have someone. But I would just submit that's what this government and all democratic governments do. They decide which broad policies of the greater good need to be funded, and we come up with a funding source where others sometimes have to pay. I will submit our own court system here. When I pay a fee in an LA County court, that money goes up to the state. It's redistributed on a formula, and that means that I may, as an individual in another county, help pay for some of the services in Modoc County or others. So I think it's a similar argument here, that there needs to be a way to fund these services. Just from a specific standpoint, from some of the counties, on average, this revenue accounts for about 10 to 15% of a PA's budget. Okay, not in all counties. I will submit that Santa Cruz County hasn't had one of these cases in 7 years. Riverside County currently has 5 cases, and it'll probably be about 20% of their revenue to fund their PA offices this year. LA County is about 12% this year. Santa Barbara has about 15% of these cases this year, which will fund their court system. So again, we realize that this has been laid out as an equity issue, as a fairness issue, but just understand that the fees that are paid by an estate to the PA, they're going to be paying more if they're paying an individual who they assign a private attorney who, again, in many cases, gets either a larger hourly rate or percentage of the estate. So I don't want anyone to be confused that if you're paying the public administrator, that is money that would otherwise go into the pocket of the potential heir. They're going to pay for the service one way or another. So again, for these reasons, we are opposed to the bill. We would ask for your no vote and be happy to take any questions.
Okay. Are there others in opposition to Mr. Lara's measure? Seeing none, I don't want the supporters or opponents to leave the table. I want there to be an opportunity for questions of both. Mr. Wagner has some questions. If I could, just want to clarify a couple things that were said by the opposition, and I want to spur a little bit of dialogue here so the committee has the benefit of the back and forth. Just a couple quick points. So first, the opposition says that there will be, if this law passes, a conflict in interest between that of the individual who appoints the administrator and the estate. That's a problem that would exist now, right? You said that the administrator would face a conflict because he or she would be appointed by an individual, but the estate may have different interests. But this bill is not about a first-time provision of authority to anyone to appoint an administrator. This is about a first-time authority for a non-resident to appoint someone.
Yes, Mr. Feer, you are correct. That situation exists today, where if you reside in the United States, you can appoint your own person.
So why is that an argument against this bill?
But the key difference is that, again, my first point, the reason why there is an extra level of security, if you will, is because once those assets leave the United States, there is no recourse for another heir who could have had a rightful claim to that estate or any other creditors. That's what the fundamental difference is and why it is different.
So the supporters say, I think, in answer to that question, I'd like them to add to this if I misunderstand this, well, no, because the administrator is herself or himself under the jurisdiction of a United States court. Typically, that administrator has to post a bond. The bond is only waived in the event that a court says the bond should be waived for reasons that presumably would have some merit. Otherwise, the court wouldn't waive the bond. And the creditors are adequately protected by those provisions. Would that be the arguments of the supporters?
Yes, that's correct.
Right. Is there any other argument the supporters would make in response to that claim? Then I want to hear what the opposition says in response to those arguments.
Well, I would also just add the comment that the administrator owes a fiduciary duty to all of the beneficiaries, and so it's not. So if one heir comes in and says, "I want my person appointed as administrator," that administrator not only owes a fiduciary duty to the person who nominated them, but to all of the stakeholders in the estate.
Right. So why isn't the fact the administrator remains under the jurisdiction of a California court personally liable, and in most cases, will have a bond? The only situation was that wouldn't be the case where a court finds that the interests of justice preclude that from being a rule. Why aren't those sufficient protections?
Okay, first of all, the bond is not mandated. Second of all, the bond does not have to be prescribed to be in the amount that covers the entire estate. It only, in some cases, the bond will be issued to cover the real property and maybe not other investments, so it may not be enough to cover all of the estate. Second of all, the most common cases where and the courts can issue the bond, and they can also waive the bond requirement. The most common cases where a bond requirement would be waived if an individual who is the nominee does not have the means to pay for the bond. And so that's a misconception that the nominee has to be an attorney themselves. In many cases, it can be a paralegal or someone who does not have the ability.
But just to be sure I'm clear, though, these are arguments that are I don't want to say an attack on, but question the efficacy of the judicial system to oversee the process, because each of your claims is, well, all the statements I've made are contingent on a judge acting properly. So the administrators are ultimately concerned, it seems to me on this point, with judges failing to execute their responsibilities properly, because presumably all the issues you've raised would be taken into account by the judge overseeing the matter. Isn't that correct?
Yes, and again, I do not mean to impugn a justice and their ability to act in these particular cases. Again, I'm just speaking from the conveyed by my particular client in real-world cases where it is not uncommon for a bond to be waived by request of the administrator. It is not uncommon for a probate process, not because of fraudulence or because the judge was not acting properly, but because of a very complicated probate process where things fall through the crack, where a creditor is not notified or made aware, or a particular heir is not made aware. Okay. And in those cases, again, there is judicial recourse after the fact. That's not available when the assets leave the United States.
Mr. Wagner, thank you for your patience. Please.
Oh, thank you, Mr. Chairman. As I see it, there are two conditions in which one circumstance where you need to satisfy two conditions for this to apply. Number one, you have assets, because we all agree nobody's going to fight if there are no assets. And number two, you've got a decedent who dies intestate. As a policy matter, my question is why, if the counties through their public administrators are coming to us and saying there's a potential problem here, we don't necessarily know how big it is, and I haven't heard either the proponents or the opponents say this is happening and it's costing us millions or billions or whatever. Okay, why would we make the policy choice to potentially burden our counties further in order to help someone responsible for the problem by virtue of dying intestate? Yes, there will be cases of 25-year-olds and whatnot, and none of them have wills. I get that. But by and large, isn't this the fault really of the decedent that the counties are put in this position in any event? Why, as a policy choice, potentially burden the counties in this tough budgetary times?
Go ahead.
Well, the fact of the matter is that many people, not just 25-year-olds, many people don't have estate plans. People die unexpectedly
through their own choice.
Actually, Mr. Wagner, let me ask a question so I'm sure I understand your question. It's the law, and again, anybody should weigh in if I misstate this. It's the law currently that an heir not responsible for the intestacy of the decedent is domestic. A domestic heir has the right to do that which this bill would provide.
Right.
All this bill does is to say that an heir, again, not responsible for the intestacy, who happens to live outside the United States should have the same ability.
Right.
Correct?
But,
So how does that affect the question?
Mr. Chairman, the crux of the administrator's issue is that circumstance where there is the heir outside of the United States. I think we all agree if you don't have that circumstance, this bill doesn't apply, the case doesn't apply, existing law is what it is, and the administrators don't have a problem with it. So to say, well, but this only applies in these circumstances is true. What changes it, as the administrators have suggested, is the possibility that they haven't quantified but is, in my sense, real, I don't know how big, that there will be circumstances where our county's budgets will be strapped in the in the interest of fairness to assist someone who dies intestate. And that's a policy choice I'm not entirely comfortable making, and I'm wondering from the proponents of the legislation why that is an appropriate policy choice, especially when budgets are as tight as they are.
Well, I suppose the question is why these people in particular. You could name, if you do decide to create a will, you can nominate the non-resident to actually act. And quite frankly, this is really it's a gotcha issue. Quite frankly, there are a lot of attorneys who aren't aware of this issue, and so as a practical matter, a lot of people don't have wills. I mean, it's one of those things that they're not familiar enough with the legal system. For whatever reason, they die unexpectedly. For many reasons, they don't have wills. And I guess the issue is it's just a question of fundamental fairness. Why these people in particular? If the argument is that the public administrator needs the money, you could just as easily say, that 1 out of every 20 probates must go to the public administrator.
No, I mean that argument doesn't make any sense at all. Because there are legitimate policy reasons and differences. You may not agree that they're compelling. I don't know that I agree they're compelling. I don't think this is a fairly close bill, but they are saying, the administrators are saying, you are potentially burdening us, and you are doing so to help somebody who has, for whatever reasons, not taken the steps they could have taken to help themselves. Right?
Well, hold on. Senator, we're not here, and I'm not here to judge folks who have a will and who don't. I mean, that's the reality. The fact is that this issue is about fairness, and you might not agree, and we're just saying, we think that the next of kin should have the opportunity to determine the will as opposed to government. I mean, we're just saying, maybe government may not be the best person to administer these assets as opposed to somebody who's their next of kin. And that's just the reality. And it is about fairness, ensuring that folks have the opportunity, and if they're a non-resident, and we're not talking about, speaking of the 1%ers, we're talking about folks who have assets here who for some reason don't have any next of kin in this country, and have their next of kin determine what the future of those assets are. That's all we're saying.
Okay. Mr. Dickinson.
Thank you, Mr. Chairman. I had a couple questions for both sides. First of all, with respect to the State Bar Committee, just as a preliminary matter, were there any public administrators, any public guardians, or anyone representing public administrators or public guardians on the State Bar Committee?
I do not believe so, no.
Okay. Now, I have a question. If a U.S. resident dies intestate, then the potential heir can nominate someone to be the administrator, if I understand existing law.
If the heir is a United States resident, they can.
Right. And so what happens if there are multiple people who claim to be heirs who want different administrators?
Well, if there are competing petitions, typically speaking, what will happen is the court will consolidate the competing petitions and basically hear the merits of the various petitions. And oftentimes what will happen is the heirs will get together and agree that a private professional fiduciary or trust company, or there will be some type of agreement to have a third party administer it if there is a conflict.
If they can't agree,
correct,
then the judge decides who the administrator is?
Correct.
And who pays the cost of those proceedings?
Well, the individual heirs who are bringing the petitions would pay the costs of bringing the petitions before the court.
They'd pay a filing fee for,
Right, they would
for
pay a
filing the
filing fee.
petition, but the taxpayers would pay for the conduct of the hearing.
Well, they would pay for their own individual attorneys, and just like any court hearing, just like any disputed court hearing, even if there's a will and there's a contest of it, it would be the same thing. The fact that there's a court, that it does take courtroom time, it would be the same type of situation.
Okay. With respect to the opponents, you mentioned some counties where you had estimated percentages of the public administrator's budget that are represented by monies they derive from representing non-U.S. residents in probate matters. Do you have a list for all 58 counties?
No, I wish I did, sir. And we've asked our PAs to check within their counties, and as you might imagine, certain PAs reacted rather quickly, and others haven't responded yet. But Alameda, $85,000 is what they figure they'll probably collect in fees this year. Doesn't sound like a lot of money, but their overall budget is $450,000. Santa Barbara's going to estimate to collect $55,000 this year. Their budget's $500,000. L.A. estimates to collect $300,000 out of a $2.1 million budget, and then Riverside tells me they're going to potentially 5 cases, maybe raise about $90,000, which would be about 20% of their particular budget. And if I could just maybe respond to your previous question to the proponents, I think what's been laid out is accurate. I will just tell you that there is another alternative where the court, in those particular cases where you have multiple heirs competing over who they want to represent them, which is very common, unfortunately, in our society when, say, a father dies and 3 siblings are all trying to get their cut of the pie. The court also has the ability, and quite commonly will refer it to the PA as the impartial entity to administer the estate. So
it would be helpful to have the entirety of the 58 counties, not just some examples.
I completely agree, and I've been sending out multiple emails. And again, as you well know, a public administrator trying to request that information and move it up through the county ranks sometimes is a slow process, but we're doing our best.
I cannot imagine that. Let's go back to the point you were making earlier about the fear of fraud based on heir hunters.
Mm-hmm.
And do you see any difference between someone who dies intestate who's a U.S. resident or citizen and someone who is a foreign citizen or has foreign heirs versus U.S. heirs and dies intestate? Is there a distinction that you draw between those two situations?
No, the potential for fraud, mistakes, misuse, and unintentional consequences, I think, exist in both cases. Again, going back to the key fundamental difference is, in the case of what we're talking about here today, if there are mistakes or if people are missed and that money goes overseas, it's gone. And now it could be that the court will come back and say there's been a mistake, and guess who gets to clean up the mess in those particular cases? The public administrator gets assigned to say, there's been a mistake, someone's come forth, go chase the money. And of course, that's added expense with no hope of getting anything in return for their services. So again, I don't intend to say that there are differences in the way the cases would be handled or any potential cases of fraud. The key difference is the money stays here in the United States under the purview of the courts.
Okay. And back to the proponents for a moment. Would you favor some sort of revenue-raising mechanism to offset the loss of money that would be felt by the counties if your legislation goes forward?
Well, in the abstract, we can't answer that question. it would depend on what the revenue raising measure is.
How about some fee on all estates?
Yeah, I just can't answer that right now.
I just want to remind the committee that this is the policy committee, and we're more than welcome to have these discussions as we move to appropriations, where I think it's best fitting to talk about fees and talk about the actual impact to the counties. I think what we need to focus here on is the fact that should these families bear the brunt for these expenses, given the fiscal the situation that we're at now, and quite frankly, continuing to discriminate with these families. And so, I think that's the discussion we should have here. And then as we move forward, if we're able to move the bill out, have the fiscal debate in appropriations.
Now, actually, may I just, for the sake of clarification, the bill, at least at this moment, is keyed non-fiscal, so it would go, I believe, straight to the floor from here. Can I, Mr. Dickinson, if I were to interrupt you just for 1 second with a suggestion, would you mind? I'm going to suggest that the author consider the following amendment, and we should wind up this conversation fairly soon. There is a concern, an untested concern, that the public administrators will suffer fiscally. So far, the conversation has been, should that fiscal concern outweigh the unfairness of the status quo? Perhaps we should consider, Mr. Lara, a sunset on the bill that allows experience to guide us a little bit. So we have a period of time in which we test whether there's any meaningful negative impact from this, perhaps 5 years. So, which would be enough time to test the principle, because people will pass away, there will be some experience on which we can draw, and then, say 5 years from now, that legislature then determines whether to re-up the bill just for consideration that might help balance some of the concerns that have been expressed today. Mr. Dickinson, I'm sorry to interrupt, but I want to put that on the table for Mr. Lara to think about as the hearing ensues. Mr. Dickinson, please.
Thank you, Mr. Chairman, and I totally respect the author's remarks with respect to money. The problem is, I just have to say, I sat and cast votes that cut the budgets of public guardians and public administrators, and unfortunately, the reality is there is not another readily available source of money. I am very sympathetic to you on the fairness argument. I'm also very sympathetic to my former colleagues who, at the local level, are searching for a way to make sure that everyone has representation in handling estates that need to be probated. And the fact is that what often falls to local government is to take responsibility for those instances in which there's no one to pay except the taxpayer, and the taxpayer, I can tell you from personal experience, has much higher priorities for how their money gets spent than probating the estates of people who die intestate and have no assets. So that's the horns of the dilemma for me here. For me, that's still something that needs to, that you've got half the loaf. You've got a right half of the loaf, but I'm also worried about that remaining half of the loaf, and candidly, that's what I'm struggling with.
Others on the committee with questions or comments? Seeing none, Mr. Lara, do you think that's a constructive suggestion to consider a sunset on the bill so we can test whether this has the deleterious effect that the opponents suggest?
I think if this allows us to continue the discussion, absolutely, or take those amendments.
Okay. All right. Colleagues, let's see no further questions or comments. So Mr. Lara has said he would accept as an author's amendment a 5-year sunset on the bill. Is there a motion on the bill as proposed to be amended? Oh, I'm sorry. As amended.
Mr. Chair, can I please comment on the potential amendment? I respect what you're trying to do here, and I'll just state that, again, we've represented the public conservatives, public guardians, and public administrators for 12, 13 years. This has been an ongoing issue for all of those entities year after year after year. There is not a dedicated source of state revenue, despite the fact that it's a state-mandated program for all of these, and it's left to the counties and the taxpayers. And we have, in years past, supported bills that impose new mandates, more work on us, because we felt it was the right policy and that was what should be done. And when those were always done with the expectation, the promises of the legislature that they were sympathetic and they wanted to find new revenue for our clients. And again, it's been 12 years, and I don't expect under our current fiscal situation that the state's going to be able to come up with something that funds all of these vital services that really do service the many needy people in our communities. And so I would just have to say that with a 5-year sunset, we will still be enduring the fiscal impact of this bill for the 5 years, and we can come back in 5 years and say, I told you so, and we can probably revisit it at that time. But we would still oppose the bill with a 5-year sunset without some source of dedicated revenue in the next 5 years to offset that. So okay. I just wanted to make it very clear we appreciate what you're trying to do, but we would still oppose the bill.
We'll hear from the supporters. Ms. Atkins has a comment, and I have a further discussion underway regarding the length of a potential sunset. Ms. Atkins.
Did you want them to respond first?
No, I'd like to. Go ahead.
Thank you, Mr. Chairman, and I certainly appreciate what you're trying to do. I have to say this has been, and as I always point out, as the non-attorney up here, me and Mr. Jones, I appreciate very much the discussion because I think it's a very close call, and I think we, in terms of the discussion, and I really do see both sides of it. I will come down on the side of the equity issue and appreciate your interjection to try to bring us to some better place. I believe the financial issues are incredibly important as someone who served in local government also. However, we face budgetary issues every single day. We are facing a budget discussion. And if we base, sometimes we have to base it on the higher policy issue and realize that we have a different dilemma to deal with. And so I appreciate your working us towards something that we could at least evaluate. And I certainly appreciate the arguments of the opponents because I do think you've made some incredible points that have caused me to sit and have to really think about it. So.
Let me do this in terms of an order of discussion. Ms. Huber would like to say something. I indicated that the supporters should have an opportunity to respond. It might make the most sense for that response to await the comments of Ms. Huber so it could be a comprehensive response. Before Ms. Huber, you speak, there's been some further discussion underway about what level of support there would be for the bill with a sunset in it. Mr. Lara, for your consideration, I think the level of support is likely to increase if the sunset were 3 years rather than 5. Ms. Huber.
Thank you, Mr. Chair. I just wanted to chime into my thoughts on this. I certainly buy the equity argument, and I do think it is a better public policy to let heirs, whether they live here or not, decide who the administrator of the estate is, because I just think that as a fundamental public policy is a fairer policy. While I am sympathetic to the budget crisis that the public administrators are also feeling right now, I do think we need to find a state revenue source, but I don't necessarily believe that it is the job of this bill to do that. To me, I separate the policy and the fiscal questions, and if we allow the bill to be bogged down by just the fiscal concerns, this says that we can never take a job that is a public job, like state services, and take something off their plate, because then they won't be able to afford to do the rest of what they have to do. And that's what we're asking here is, should we take this set of probated cases off the plates of public administrators? They will suffer a budget consequence, but that doesn't mean it's not a good policy decision to take it out of the realm of the public administrators. I worry about the implications of our decisions that when we stop doing something, either a local government service or a state service, that when we stop doing it, we can't stop doing that because then we won't be able to fund state services. That shouldn't be our guiding argument. It should be whether it's a good policy or not, and if there is a separate need for making sure that they have the funding to do their job, then that's a separate discussion that we also have to have in order to ensure that public administrators can continue to do the job that they do.
Thank you.
Thank you. So now, with all this discussion in mind, and with the prospect of, as I said, support for the bill likely to increase if it were a 3, not a 5-year sunset, the supporters of the bill have a comment.
Yes, Mr. Chair. Assemblywoman Huber, I think, articulated our point much better than we could do it. This bill has always been about people that are being harmed, and today families are being harmed solely because they are non-residents. We wanted to just to remove that inequity in the law with this bill. If it makes people feel more comfortable to put a sunset in the bill, we're certainly open to it, so long as Assemblymember Lara is also open to that type of provision.
So, Mr. Lara, we've reached the concluding point. As you conclude, would you accept an author's amendment to have a 3-year sunset on your measure during which we can determine whether the negative impacts that the opponents suggest are likely to occur do in fact take place? If so, if you'd say that in your close, and we'll have a vote. Please.
Absolutely. I would take that as an author's amendment to limit it to 3-year sunset and see what the outcome is and how we move forward after the 3 years.
Okay. Mr. Monning, would you revise your motion on the bill to reflect the 3-year sunset?
Yes, as amended.
Okay. Is there a second to Mr. Monning's motion? Ms. Atkins seconds. I'll take that as your close. Mr. Lara, call the roll.
Fuhr.
Aye.
Fuhr, aye. Wagner. Atkins. Atkins, aye. Dickinson. Dickinson, aye. Huber.
Aye.
Huber, aye. Jones.
No.
Jones, no. Monning.
Aye.
Monning, aye. Wachowski. Wachowski, aye.
That bill has 6 votes and is out.
Thank you.
Thank you. All right. Now, we have Ms. Atkins' bill. Typically, we hear from non-committee members first. Does Ms. Lowenthal's staff... Oh, Mr. Dickinson, present. Fine. Mr. Dickinson, why don't you present on behalf of Ms. Lowenthal, and then we'll conclude Ms. Atkins' bill. So the measure on which Mr. Dickinson is presenting is item number 4, AB 1634. While that is pending, is there a motion on Mr. Gatto's bill, item 2, AB 1624? Is there a second? Call the roll, please.
Fuhr.
Aye.
Fuhr, aye. Wagner. Atkins. Atkins, aye. Dickinson.
Aye.
Dickinson, aye. Huber. Huber, aye. Jones. Jones, aye. Monning. Monning, aye. Wachowski.
Okay. That bill is out.
Wachowski, aye.
Mr. Dickinson, thank you. You're up on AB 1634.
Mr. Chairman, thank you. I'm happy to present this bill on behalf of our colleague, Assemblymember Bonnie Lowenthal, and I'm also happy to accept on her behalf the suggested committee amendments. AB 1634 would require investigators who send solicitations about unclaimed property to include on those solicitations the contact information for the entity holding the property. Currently, financial institutions, businesses, and associations are required to turn over financial property to the state controller's office when there's been no account activity or contact with the owner for a certain period of time, usually 3 years. Many of us have become more familiar with this process in recent years. Some of us even get letters from time to time from the state controller saying you ought to make a claim for some property that maybe you overlooked or forgot about.
Do you have a philanthropic donation you wish to share with us today, Mr. Dickinson?
I'm sharing several with the state.
All right.
So. This property can include bank accounts, insurance policies, stocks, and similar kinds of items. The controller's office, after getting notice, tries to contact the rightful owner or heir of the property. And investigators, in fact, comb through the state controller's inventory and then sometimes send solicitations to owners claiming the investigator can get the owner's property back for a fee. Now, what many owners don't realize, maybe some of us don't even realize, although I hope we all do, is that the person who's entitled to the property can contact the state controller's office, fill out a form, and have their property returned to them at no cost. So, why this bill? This bill would require investigators to notify consumers where their property is being held so that consumers can make an informed choice. Currently, investigators are required to include that kind of contact information on contracts, but oftentimes people agree to enter into an arrangement where they will have the investigator go search out the property and not know that, because they haven't seen the contract yet with the investigator or signed it, not know that they can do it themselves and do it for free. So in this respect, we hope that the bill will result in more consumers being reconnected with their property when they have the legitimate right to that property, and they will know that on an informed basis they can do that without using any assistance, unless they choose to, on an informed basis and without cost. I have with me Ruth Holton Hodson, the property owner advocate for the State Controller's Office, to answer any questions, and I would respectfully request your aye vote.
Thank you. The bill's been moved. It's been seconded.
I'd like to thank your committee staff for working with us on these amendments that we are accepting today. I respectfully ask for your aye vote. Thank you.
Thank you. Others in support? Other members of the public wishing to state their support for Ms. Lowenthal's bill? Are there opponents of the bill? Seeing none, the bill's been moved and seconded. Colleagues, question or comments for Mr. Dickinson on behalf of Ms. Lowenthal? Seeing none, Mr. Dickinson, you wish to close?
I would respectfully request an aye vote. Thank you, Mr. Chairman.
Ms. Lowenthal would be proud. Please call the roll.
Fear.
Aye.
Fear, aye. Wagner. Atkins. Aye. Atkins, aye. Dickinson.
Aye.
Dickinson, aye. Huber. Aye. Huber, aye. Jones. Aye. Jones, aye. Monning. Aye. Monning, aye.
That bill has sufficient support and is out. Ms. Atkins, AB 1522, item number 1.
Wachowski, aye.
Okay, Ms. Atkins, before you start, there was an error. Mr. Wachowski's name was not called on item number 4. Mr. Wachowski, your vote?
Aye.
Thank you very much. Ms. Atkins, please.
Thank you very much, Mr. Chairman and members. I would like to start by accepting the 2 amendments described on page 5 of the analysis. I want to thank you and your staff, Mr. Chairman, for working with us to address concerns about the availability of attorney's fees in future litigation between spouses related to their children. Even with this very limited amendment, AB 1522 provides strong protections for victims of violent sexual felonies committed by their spouses. The bill closes a loophole in the law that has forced victims of violent sexual assaults to pay alimony, attorney's fees, and other financial benefits to their abusers in a divorce proceeding. AB 1522 prohibits awards of alimony and community property interest to individuals convicted of violent sexual felonies against their spouses. The bill also limits attorney fees awards to the victim's the convicted spouse. Someone who rapes their spouse should not be then able to turn around and just make their victim support them following a divorce just because the victim makes more money than the rapist. That's just not fair. But that's exactly what happened to Crystal Harris, who is here with me today. The law already prohibits those convicted of attempted murder of their spouse from taking their victim's assets. But through a loophole in the law, a rapist can now victimize their spouse twice, once during the rape and then again by forcing them to pay their abuser. Victims of violent sexual crimes already suffer physical trauma, fear, and an assault on their privacy and their very dignity. To require them also to pay their abuser alimony or to give them a share of their pension or household goods is cruel and makes a mockery of the intent behind the laws governing the fair division of assets in a divorce. AB 1522 is sponsored by the San Diego District Attorney's Office and supported by law enforcement, victims advocacy organizations, and others who believe in stronger legal protections for these victims. With me in support today and the sponsor are San Diego Deputy District Attorney John Rice and certainly Crystal Harris, the individual whose tragic case inspired this important bipartisan legislation. I respectfully request your support for AB 1522. Happy to take your comments and your questions.
Thank you, Ms. Atkins. Your first witness in support, please.
Good morning, Chairman Fuhr, members of the committee. My name is John Rice. I'm a Deputy District Attorney, and I'm appearing on behalf of San Diego County District Attorney Bonnie Dumanis, a sponsor of this bill. I've been a Deputy District Attorney for 25 years, and over the last 10 years of my career, my focus has been in the sex crimes area. I'm currently the Assistant Chief of the Sex Crimes and Stalking Division. I've seen firsthand the emotional and physical damage wrought on sexual assault victims. Historically, it's been said that sexual assault victims are victimized twice, once by their assailant and again by the criminal justice system as it seeks to obtain a conviction. Over the last 20 years, significant changes have been made in the area of victims' rights, and specifically as the law relates to sexual assault victims. They now have a right to have an advocate present, to keep their name out of the public documents, and not to have their sexual history delved into by the defense. While it is by no means a perfect system, it has become much more user-friendly, and it's thanks largely to the efforts of the legislature. Now, through the horrendous experiences of Crystal Harris, we've learned that the sexual assault victims are being victimized in yet a third arena, that of the family courts. In the family court arena, spousal support, retirement funds, insurance benefits, all can be placed in the hands of the assailant by the family courts using formulaic determinations that ignore the fact of their sexual assault and their victimization. Furthermore, the convicted spouse can collect attorney's fees to continue their assault on the familial stability and financial stability of the victim. AB 1522 adds victims of the violent sexual assault to the pre-existing classes of attempted murder victims that enjoy the protection of Family Code Sections 4324, 782.5, and 274. It also expands 4324 to include attorney's fees, except where child custody and support issues can be shown to be in the interest of justice to be awarded. This legislation will be a step forward in ensuring that the judicial system protects and does not continue the victimization of rape victims, and that they may count themselves as survivors and not victims.
Thank you for your testimony. Next witness in support, please.
Mr. Chairman. Thank you. Mr. Chairman and members of the Judiciary Committee, my name is Crystal Harris, and I'm here to testify in support of Assembly Bill 1522. I come before you today representing all victims of domestic violence who suffer under Family Law Code. Assembly Bill 1522 is necessary to protect victims of sexual violent felonies from being victimized again when they step into family court. I am one of those victims. 4 years ago, my husband raped, sodomized, and forced me to perform oral sex. He also choked me, beat me, and threatened to kill me, all while our 2 preschool-aged boys were awake upstairs. Frozen with fear by his death threats, I did not call the police after his first attack. But 5 days later, he raped me again with an extreme escalation in the violence. This time he choked me to the point that I thought I was going to die. I survived that attack, but I knew I would not survive the next one. I would be dead. And so later that same night, I snuck out of the house and I called 911. My husband was arrested and eventually convicted by a jury of sexual assault, and he's now in prison for 6 years. After starting divorce proceedings, I once again became the victim of California Family Law Code and my husband's greed. It mattered not that the whole reason we were in family court was because of my husband's brutal crimes against me. It mattered not that being ordered to pay my husband's spousal support every month amounted to making a rape victim write a check to her own rapist every month. It mattered not that my husband was now using the family court as a way to bully and harass me and rack up over $100,000 in attorney's fees for himself alone, figuring I'd have to pay them. I was humiliated when my husband won all of these awards and saw him laughing at me. The law said that his crimes against me were but one of many factors for the judge to consider when deciding spousal support and attorney's fees, and the judge could give that factor as much or as little weight as he wanted. The law said he was entitled to half of my retirement and pension funds. The law did not care that it cost me additional attorney's fees to try to protect my children, who were also victims, from being forced against their will to visit their father in prison. Assembly Bill 1522 fixes the law so that a violent sexual felony is included with attempted murder in precluding a convicted spouse from obtaining these awards, regardless of the other factors. Please pass Assembly Bill 1522 and give violent sexual assault victims some guarantee of peace of mind and financial protection so that she's not again the victim of both the court and the convicted spouse. I respectfully ask for your aye vote. Thank you for your kind attention.
Thank you for your testimony. Next witness in support.
Thank you, Mr. Chair. Members, Dawn Kepke with McHugh Kepke and Associates on behalf of Crime Victims United of California in strong support. We commend Ms. Atkins, DA Dumanis, and especially Ms. Harris for her courage in coming forward and working to effect change in this area, and we strongly support. Thank you.
Thank you. Other witnesses in support.
Good morning, Mr. Chair and members. Corey Salzello on behalf of the California District Attorneys Association. We are a co-sponsor of this bill. We think it's appropriate to add violent sexual felonies to the list of offenses, specifically attempted murder and solicitation of murder, for which these provisions already exist.
Thank you. Others in support.
Thank you, Mr. Chair. Members, Kathy Christian. On behalf of the San Diego County Board of Supervisors, we're proud to join Ms. Atkins and the sponsors of this bill. We urge your support.
Thank you.
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. As prosecutors, we believe it's our duty and obligation to protect victims from being re-victimized by the justice system. For that reason, we strongly urge you to pass AB 1522.
Others in support.
Christine Ward with Crime Victims Action Alliance. We support crime victims' rights and public safety and believe this is a very important bill. We strongly support this. Thank you.
Rebecca Gonzalez, National Association of Social Workers, California chapter. We support this common sense measure.
Mr. Chairman and committee members, my name is Barbara Bentley. I am a survivor of domestic violence and the author of A Dance with the Devil, a true story of marriage to a psychopath. In 1995, I sponsored AB 16 that became the law that AB 1522 seeks to amend. I wholeheartedly support the 1522 and humbly ask for your aye vote. Thank you.
Thank you.
Alexis Marbach from the California Coalition Against Sexual Assault, representing over 84 rape crisis centers throughout the state, and we strongly urge your support.
Any other witnesses in support of Ms. Atkins' bill? Are there opponents of the measure who wish to testify? You may come to the front. Good morning.
My name is Jill Barr, and I'm representing the Association of Certified Family Law Specialists. We're a group of about 550 family law specialists in the state of throughout the state of California. We ask that the committee deny this this bill. The addition to 782.5 is problematic in that the circumstances can be imagined when the results would be unjust. The remedy has no nexus to the behavior, and we should not be adding crimes to this section. We seem to be going down a slippery slope, and one wonders where we will draw the line ultimately on this section. The crimes that are to be proposed to be added to Section 4324 should certainly be a factor in determining spousal support. These crimes can be enumerated in Family Code Section 4325, which maintains the court's discretion. Again, there are circumstances, of course, the circumstances that brings the bill here are horrible, but there are other cases where circumstances can be imagined where the results would not be favorable. And then we would have to amend the code again. Maintaining the court's discretion in these cases should be maintained. Attorney's fees should be left to the discretion of the court, and we ask that you deny this bill.
Thank you for your testimony. Others in opposition to the bill? Seeing none, Ms. Huber wishes to offer some questions.
Actually, I was going to have you stay, if you don't mind, because I'm having a really hard time understanding the opposition. I understand that you want the judges to continue to have discretion, but we as a policy-making body certainly have the right to make a predetermination on policy grounds that someone who is convicted, this isn't just charged, this isn't just allegations being made by a petitioner or respondent in a divorce proceeding, this is an actual conviction having an impact on the divvying up of property in a family law proceeding. You say there are cases that can be imagined where it wouldn't be a just result. And when there is a conviction of the enumerated violent sexual crimes that are defined in the bill, I'm having a hard time even conceiving of one of those cases where the result would be unjust if we adopt this bill. Could you maybe give me an example?
Sure. One would be in year two of a marriage, a spouse pleads guilty to this one of these crimes that we're seeking to add to this section. And in year 5 of the marriage, the parties don't get divorced, the person goes to jail. In year 5 of the marriage, the parties reconcile. And 15 years later, they get a divorce. Community property is accumulating during that time period. The parties have reconciled, and in that dissolution, the convicted person would be denied their share of the pension benefits.
Thank you, Ms. Huber. Mr. Wachowski. And then Mr. Jones.
I'm concerned about the legislation. I understand it's an unpopular position to take, and my sympathy goes out to Ms. Harris, but bad facts can make for bad consequences in the law, and I am seriously concerned about adding these crimes to Section 4324, and where do we continue to do that? Part of the arguments, and this is for the opponents, part of the argument has been made about this payment of attorney fees. And I guess I understand from the facts of Ms. Harris's case that this was a stipulated agreement to pay attorney fees that they had, and there's a monthly amount that has to be paid. In the family court scenario, isn't that the discretion that we want the family court justice to have, so that everybody, regardless of where they come, how unpopular they are, they have access to the family court services?
That's correct.
And again, if I move past the facts of this case, doesn't that, by limiting that, limit the family court? I mean, it's been characterized as victimization to go into family court, but isn't family court sometimes protracted, sometimes difficult time? But the judges have the ability to limit that award. It doesn't necessarily, I mean, here we had an agreement between the parties and their attorneys, but the judge didn't actually come up and say, I'm going to victimize you again. They just implemented what was going on.
That's my understanding.
And that there's nothing in the family code that would prohibit a judge sitting in there and listening to all the facts from limiting that award of attorney fees. It's a discretionary
That's correct.
Judgment. The other argument proponents is that this sort of is the idea that spousal support is being awarded, was awarded from the time from sentencing to the time that the conviction, and the judge based that on the disomaster that comes in. Now, my understanding, it wasn't in the report that we got, but it was the judge who, upon conviction, stopped the spousal support.
Right. This bill would not change that scenario.
And then under the current law, all the judge did was advise the parties that after release from prison or any, I mean, it doesn't have to be this crime or the crimes that are being included, any crime, they terminate spousal support. But under the law, the judge had the responsibility to advise the victim in this case, or the respondent, or is that person, once they're released from prison, they have the right to petition the court. But it's not automatic. It's a petition. Right. I mean, there's some sense that this automatically, you get to start paying spousal support, which is different in family court. The court would obviously look at all the facts. I mean, the family courts are a difficult venue with lots of difficult circumstances that they go. So there's not a mandate now in family court that people that would be released from prison would automatically receive these suites.
Rakowski, maybe I'll go to Mr. Jones, and if you have further questions, I'll return to you. Is that okay? Or do you have any?
No, that's okay. I lost my train of thought, but I think that
I'm happy to return to you when you like. Mr. Jones.
Thank you. Thank you, Ms. Atkins, for bringing this bill, and as an early co-author, I applaud your efforts on this. To the DA's office, thank you for Bonnie Dumanis, the DA, taking the leadership on this issue. And Ms. Harris, thank you for your courage to bring this issue. I know it's difficult to testify at any committee hearing, but especially on a personal note like this, I applaud your courage to be able to do that and not remain a victim, and I applaud your efforts to overcome that. Thank you.
Thank you. Mr. Rakowski.
Support the bill.
Thank you. Mr. Rakowski, anything further?
I understand that family law, and this is maybe for the proponents, is that there's a rebuttable presumption against giving spousal support. So the presumption is against the criminal in this state from awarding it. It's just under extraordinary circumstances, I believe, that they would give the award. Why is that a bad tool for family courts to have? I guess.
Well, I will attempt as the non-attorney to respond, and then let the sponsor. I guess the point I would like to make, Mr. Wachowski, is that we know that family court can be difficult, and we know that families in crisis and in disagreement, many things can happen and play out. And I have the greatest respect for attorneys who work in the family court system. I certainly understand the part of their job representing clients is to preserve as many options as possible. This is not just a case of a couple whose marriage is breaking down and they're in dispute. Violent sexual crimes, convicted of that crime, is the expansion that I am looking for in 4324. And recognizing the importance of judicial discretion and how significant that is, it is why we sought a very narrow expansion. It's why we worked with the chair and the committee to make it very specific. I focus on, we step away from the intent of the original statute related to murder, conviction of murder or attempted murder, violent sexual crimes, convicted of. And in response to your comment about settlements and the stipulated settlement, I guess I would say I've been in a very interesting situation as a city council member who has to agree to settlements in closed session. I can only imagine what it would be like to be forced to want to be done with something that in the case of Ms. Harris, where you stipulate and agree. I don't know the story behind her acquiescence to that, but I can only imagine the desire for something to be complete, done, and to put it behind me. That may not answer some of your technical attorney questions, but in my attempt to understand what we were doing here, it was to focus on violent sexual crimes, person convicted of. Mr. Rice, did you want to?
Yes. Mr. Wachowski, you've raised the statute 4325, which is the rebuttable presumption you're talking about after a conviction of domestic violence. Domestic violence, while it is a serious crime, the violence can be as low as a battery threshold, a simple battery. Mm-hmm. In this section, we're talking about violent sexual assaults, and it's a very short list, but it's a very serious list, the crimes that are involved. You talk about the solution being the rebuttable presumption in 4325. That may be overcome by a preponderance of the evidence. But in this situation, we're talking about someone who's been convicted by a jury beyond a reasonable doubt of a violent sexual assault, an extremely high threshold. And I don't think that the protections under 4325 should apply to someone who has been convicted of such a serious crime and to that degree. I think that the law that exists protects victims where it relates to attempted murder, and I think it's the sponsor's belief that a violent sexual assault should be treated in an equitable fashion.
Thank you. Is there a motion on the bill? Bill's been moved and seconded. Is there any further comment from members of the committee? Seeing none, Ms. Atkins, like to close?
Thank you, Mr. Chairman. I would thank you for your comments, questions, and would ask for an aye vote.
Okay, so the bill has been moved and seconded as amended by the author's amendments. Call the roll, please.
Fuhr?
Aye.
Fuhr, aye. Wagner? Atkins?
Aye.
Atkins, aye. Dickinson? Aye. Dickinson, aye. Huber?
Aye.
Huber, aye. Jones? Aye. Jones, aye. Monning? Aye. Monning, aye. Wykowski? Wykowski, no.
That bill has 6 votes and is out. Congratulations, Ms. Atkins. So that concludes our agenda. I will remain for approximately 1 minute. I have multiple other commitments if Mr. Wagner wishes to return to add on. But I have to get out of here, so I have here.